Faith presiding is now in session.
Ladies and gentlemen, welcome back. Please have a seat. Jury is returned. Counsel and the defendant are present. We're on the record. I think I made that clear before we left. Both the state of Ohio and the defendant have rested. You've now heard all of the testimony, all the exhibits, and all the evidence has now been admitted. The next phase of the trial is closing arguments. The state has the burden of proof. The rules allow the state to argue first and last. As I told you the first day that we were here, statements of counsel are not evidence. The evidence comes from the sworn testimony from the witness stand and the exhibits that have been admitted into evidence. Closing arguments of counsel are designed to assist you. They're not evidence. All right, Mr. Moser, on behalf of the state of Ohio, you're prepared to argue?
I am, Your Honor.
Ready to proceed.
May it please the court.
Sir.
Counsel, ladies and gentlemen of the jury. First, I'd like to thank each and every one of you, as well as our alternates, for the time that you've given to this case. Now I have an opportunity to look you right in the eye instead of ducking around corners as we go to the elevator and whatnot around the courtroom and the courthouse. You will have a number of tools in your toolbox when you decide this case. Those tools will come from the judge in his charge to the jury. They're called instructions. And you'll learn from that that a trial is not a free-for-all on what you think the law should be, ought to be, might be, could be, what you might want it to be. It is what the judge tells you it is. So you'll learn from that how to apply the rules of evidence and law to questions of credibility, who's telling the truth, things like that. There are some tools that can't be in your toolbox, but in a case such as this, if we are now in the no-skin zone, you need, and I need, to tell you what I know and understand. You will want to consider, but you can't. And I need to address those one at a time. Number one, how could anyone believe that a person would recklessly hurt a 2-year-old child? You all bring that in because you're all good people. You come from fine backgrounds. You wouldn't be selected for this specific work. And you want to believe that nobody would do this to a child. And that's something that you hold in your minds. You have to fight to push back against, because you can't allow that to interfere with your decision and how you look at the facts of this case. The next benefit that a defendant has in a case such as this is how can sympathy be avoided for a hard-working, employed person? Is there any doubt that this defendant is a hard-working and employed person? You feel badly for that? Of course you do. And who wouldn't? That's what we want in people in our society, hard work. But you don't get a pass for that. You don't get a pass for that when you commit a crime. And that's what the state of Ohio is asking you to find in this case, that a crime of murder was committed. Not that he intended to. Not that he even knowingly did that. But that he committed a reckless act of child endangering, using a child in such a way that death was caused. Those are in the instructions, and they're very simply stated. So I'm not going to spend a lot of my valuable time going through what you are all capable of reading and understanding from the jury charge. It's in very simple, plain, ordinary language, and when you read it, you'll see it, and you'll understand what the specific charges are. You'll learn about evidence and circumstantial evidence, what it is and what it's not. You'll learn about inferences and what they are and what they're not. And those we ask you to apply in this case, but to leave the sympathy part alone. The next benefit that a defendant in this case has is that he is a veteran from Afghanistan, having served there, having served there. Do you thank him for his service? You bet you do. Do I? You bet I do. Does any good American believe in our veterans and the service that they provide? Absolutely. But you can't let that fact interfere with your judgment in this case, because judgment is all you can do. not decide this case on something such as that service. Is it a good thing? Sure. Does it play any role in this case? No. Unless you think it might, because after all, remember, his service was that of a medic who was supposed to be helping people fight pain, not causing a 2-year-old to experience more pain than that child should ever experience. And lastly, you might say, with respect to the advantages a defendant brings into a case like this, special circumstances of this case, you may say, well, isn't it enough that a failed mother has already been held accountable? Isn't one enough? Why does the state want more? Because in this case, the mother has been held accountable, but the person who caused this child to die has not. Now, with all of that being said, and knowing that you will put all of those circumstances out of your mind with respect to those types of tools, this case is actually very simple addition. And I don't overstate it when I say that it is as simple as 1, 2, 3, and 4. Number one, the direct evidence is, and it is not an inference, it is direct evidence, that the defendant was alone with the child, when the child woke up screaming. And then the child went limp. And then the child and the defendant went to wake up the mother. The defendant did that. And then the child goes out to the hospital for examination. Now, that is an immutable fact. It is direct evidence, not circumstantial evidence. And you know that, we'll discuss it in a moment. EMT Peters and what the defendant told him. Next, at the hospital, we end up with that first critical x-ray of the brain, showing a minimal amount of swelling, perhaps some bleeding that might have predated that, but there was a minimal amount of swelling, and then 2 hours, 25 minutes, there's a whole lot of swelling. And all of the medical experts told you, which is uncontroverted in this case, not one medical expert was called by the defense to rebut that abuse was caused. That abuse was caused, and as a result of that, the child died. That is unrebutted, uncontroverted. Does anybody doubt it for a second? Of course not. Because these are experts that deal with this. The Hamilton County Coroner. I would argue she had to be tremendously impressive. Along with the radiologist, tremendously impressive. Along with the pediatric doctor, impressively stated abuse was the cause. And the ophthalmologist who said hemorrhages in the eyes, those were caused from shaking. Now the judge is going to tell you that it is not necessary for the state of Ohio to prove whether it was shaking or some other assault. But what the state of Ohio has established is that the injury, and the coroner said to you, the injury was minutes, not hours. That's when the injury occurred. Minutes, not hours, when that child went limp. Who's with the child when the child went limp? The defendant. The mother was off in the other room. The defendant had that child. You put those together, it is as simple as 1, 2, 3, and 4. I know it's sometimes, well, is he making it too simple? Some cases are just that simple. Now, they're not that simple if you have an expert who comes in and says, oh, wait a minute, no, this wasn't abuse. This child's injuries were caused by falling off a chair. No, this was caused by, even those minor little fender bender out in the community somewhere, where somebody either slammed down his brakes too hard to tell the child to stop screaming, or there was somebody that stopped in front of them and they had to stop the car real quick, or the child fell off a chair. If you have a doctor who comes in and says that, well, now then we've got a contest now, don't we? Yes. And then it wouldn't be simple addition. Then I would have to be pitting our experts against their experts. But when you look at the curriculum vitae, the summary of her credentials, Dr. Carre, what a magnificent doctor, dedicated her life to study an analysis of what happens when children are abused. And that was her conclusion. She actually gave the defense the benefit of saying, well, it was within hours. She just put the swelling within hours of the going limb. Okay. But she also said it was certainly after midnight. Well, after midnight, there's only 3 people that are associated with this case, and that's the defendant, Ms. Kinner, and Kinsley. That's it. Unless you think somehow Fred's involved, or Mr. Diesbach is somehow involved in this, which certainly is not the case. Nobody suggests that. So let's go back and examine whether or not it's as simple as all of that. What about that statement where I say to you that Brad was alone with the child? Where does that come from? It comes from an EMT who's on his way home, or just got home, or whatever. He's off duty, but now he's going back on duty to help what they call a non-breather. He's got a baby, he's got an infant, and he's going to help. And when he gets there, along the way, he wants to know what happened to this child. It's important. It's important because if they're going to treat this child for something that's going on, they need to know whether is there some epilepsy involved here? Do we have a history of this, that, or the other? Tell us what's going on here. Tell us what's going on here. He's not a policeman. He's not working for the sheriff's department. He's just an EMT doing his job, getting information. And what are the odds of him inventing some statement like the one he said in the history that ends up in the medical records on December the 2nd? You play that for you, Kevin, please. I've taken some snippets just so that you can see some things plainly and clearly. History, HX, that medical lingo for history. Patient woke up screaming and crying and then became unresponsive per boyfriend on scene. Boyfriend stated he had child asleep on his chest prior to the incident. Boyfriend stated he went to wake up mother after the child became unresponsive. What are the chances of him making that up on December the 7th at 7 o'clock in the morning? And you'll have that, by the way, and you'll see the pages. It's in State's Exhibit number 6. You can see the time. It's not up there, but it's in the record. You've got it. You'll have it. You'll see it. What are the chances of him inventing the idea that the child's on this fellow's chest, he wakes up, the child wakes up screaming, and then he goes and gets the mother? About a gazillion to 1. But let me just put it this way to you. If you believe for a second, you decide that he lied to you somehow about what he's saying, about the medical thing that ends up in the record for the purpose of treating this child, if you think he's lied and lied to you, you go back in that jury room and you find the defendant not guilty. That's what you believe, because you're the jury. Sure, I want to be the 13th juror. I want to be the one that's helping along here and giving you some arguments to counter some arguments that might be made in the jury room. So when somebody says, perhaps on the jury, well, how do we know if Peters is telling the truth or not? Okay, maybe he's not lying, but maybe he's just mistaken. Remember about that possibilities and, evidence could be possible and probable and might be and could be. And all of those things that the defense talked about on this exhibit, you know, the probability chart of when you have to find somebody not guilty. That it could be, might be, ought to be, whatever all of the possibilities are, okay? Well, you know, there was a frontier lawyer who was challenged with the same problem. Same problem. Frontier lawyer. Great frontier lawyer. My hero. Probably yours too, maybe. His name is Abraham Lincoln. And he had the same problem. When somebody posited all of the possibilities, could be, might be, maybes, and he said, let me give you a riddle, members of the jury. If you call a dog's tail a leg, how many legs does that dog have? Because a tail could possibly be a leg. A tail might be a leg. It might be a leg, but at the end of the day, a tail's just a tail. The dog only has 4 legs. So the bottom line is, there's no possibilities about this issue with respect to EMT Peters' statement. He wasn't mistaken. Well, is there anybody else that says this? Is he the only one? Should we rely on just him in this whole case, that the defendant was alone? Well, how about Deputy Romans? A deputy sheriff, a patrol officer, he's out on doing people's work, and he remembered the defendant saying the same thing to him. The same thing to him, and what concerned him is that the defendant saying he was alone on the couch with the child and went to wake up the mother, and the mother saying that she's in the bedroom and they're both together when it all happens. He thought that was inconsistent. In addition to the fact he's seeing a child with injuries, so did the EMT Peters, and everybody's seeing something going on with this child as far as bruising, and they're all concerned about abuse. And when he has 2 people giving inconsistent stories, he doesn't know that this child had woken up earlier in the bedroom when they were both together. Perhaps Mrs. Kidder slammed her stories together. Who knows? I don't know. The bottom line is they were in the same room for some period of time, and they went out into the living room together. But then she did go back, leaving the defendant with the baby, just as he said, before he figured out that maybe that wasn't such a good idea. Because there's a text message then that comes a little bit later. And this is a critical text message for you to consider in the application of the evidence to this case. Because it mentions the couch in a particular way that keys in on the couch at that point as being the place that only one person would know for sure where everything happened. That's the couch, and that's the defendant. If you would play the text message, please. Tell him. They're going to try and make us look like bad parents, babe. Not sure how they got 3 different stories. Either Chuck never said anything. This is stupid. I love you, stay strong, and we'll be with you soon. And she says, I know, babe, I love you, 7:14 in the morning. And that's just for context. That's not anything that you have to believe with respect to Rebecca. And then he says this, just telling them she was lying with both of us in the living room, in the couch, so they don't try to turn it around you or me. Now, if they're both together on that couch, you don't need to be telling her, tell them we were both on the couch together so they don't try to turn it around on you or me. But what is he worried about turning it around about? It's turning around about something that happened on the couch. Now, if he said, tell them we were in that crash a couple of days before, which we know was a lie that she wasn't even involved in. Why do we know that? Because it says in a statement that he gave to the police. But before we get to that, he didn't say to her in that text message, hey, just look, this is crazy. You got to tell them about falling off the chair. You got to tell them about hitting the head on the sink. You got to tell them about the car crash. All of these things that he happened to be around the child and she wasn't. Seems like he's with the child an awful lot during that period of time when the child shows up with a lot of different bruises and things of that nature. No, he doesn't say anything to her about that. It's telling them we were on the couch together. Why does he key in on the couch? Because he now knows that the couch is where that kid went limp, and he's the one that did it. He's the one that did it. So, with respect to EMT Peters, and with respect to Deputy Romans, you have proof beyond a reasonable doubt, not based on an inference, you have proof beyond a reasonable doubt, in addition to his statement, his text message, that he was alone on the couch when the injury to the brain occurred. And only after then did he get the murder. And during that period of time, we know from the coroner and from Dr. Curray and the pediatrician and the ophthalmologist that the abuse was caused at that time. That's what happened. It was abuse. As the coroner said, this is a homicide. This is not an accident. And this is not the worst case of suicide you've ever seen by a 2-year-old banging her head on a wall somewhere on purpose because she's frustrated about something in her life. That didn't happen either. That's just crazy talk. It didn't happen. The defendant talked to the police, and everything I am going to be talking to you now about a statement from the defendant, I want you to know I'm referring to the statement in which he was in the room with the detectives. This is what I'm referring to. I want to be very careful to make sure that we're very clear on this concept. What did we learn from the defendant in that statement? We learned that he told his story, and he's sticking to it. He's calling that tail a leg, and that's the way it is. Not going to change it. Does it make it true? Based upon what you saw on the interrogation, I'm glad he didn't admit it. Now you're saying, what? The prosecutor saying you're glad somebody didn't admit it? I'm glad he didn't admit it because there is some evidence in this case. I know you felt it. I felt it. What I felt doesn't make any difference. Strike that myself. I think you felt the idea that he was browbeaten a little bit. Police officers were threatening. And I don't like the idea of any police officer telling you, the jury, through a suspect on what you as a jury are going to do. I don't like it because I don't want you to be contrary and somewhere along the line say, well, we'll show them a thing or two. They might think we're going to do something, but we'll prove it just the other way to make a point. I don't want you to do that. And I don't want to spend hours and hours and hours worrying about whether or not you're going to decide a case on a confession that you might feel was browbeaten out of somebody. No, nobody laid a hand on it. Was he threatened with prosecution? Sure. He was threatened with a charge, which he was. What they told him they were going to do, they did. But nevertheless, you could certainly feel a little bit of anxiety, I suppose might be a word, for that situation. So he said his story, he stuck to it, doesn't make it true. And I don't have to fight the idea that he made a, quote, false confession, which is a benefit to me. But I do know that this statement, nevertheless, told you a lot about this defendant. How did he do that? Well, you know that he can lie. And you know he's pretty skilled at it. Pretty skilled at it. Not one of you, I believe, ever doubted for a moment that this fellow, the defendant, was in a car crash with Rebecca. because it just tripped off his tongue about her being in the car. We were in it, and she hopped out, and she went and checked. Wait, let's just hear it in his words rather than me paraphrasing. No, it's not it. While they're doing that, let me just tell you, I'm a dinosaur. I don't usually do this, but here we go.
It was actually, I'm pretty sure it was Friday. I don't quote me. It's either Friday or Saturday. I'm pretty sure it was Friday. We were going down the road, and somewhere was it? That Main Street, I think it was. Pretty sure it was Yellowtown. And coming down the road, and doing the speed limit, and loading up, crossing roads or second road, whatever you call it. And we got toward the field, right? They get to the park, right from us. So she slammed her brakes, locked the brakes up, and it barely bumped the car. We were in the field, so she locked the brakes up, and, I heard forward, and my hand was dash, and as soon as we came to stop, her Kinsley was actually screaming, top of the wall. Yeah, that's why I was thinking, I just scared to death, I hopped out. Right, next thing you got, I hopped out freaking screaming and cussing at the driver of the car. What the fuck are you doing, Watch where you're going, come out quicker, wait till we pass, anything like that. Well, something is back she up, make sure she's all right, calm her down, make sure she's good. Look at her, she had a little pink one where they put one picture right here. I mean, probably no bigger than he left in. It wasn't bad, I just, straps. Yeah, her mercy belt, that came to the fault, I think. She pinched her and she did the headband, I think, that hurts. No, we ran into her, especially everybody done it, she did see her. And we went home, didn't think anything about her, and she said, she broke her neck, and she's a little kid, she said, all her, started getting like, she was proud of it. She didn't say anything else, she was good. She acted like nothing was wrong. No issues, she didn't have anything bother her. She slept a lot the next day. I told her, hey, she real weight, removed and everything else, she shouldn't have to like she hit her head over really anything. I think her bottom may have hit her in the head or something, but the bottom may have hit her. I think she's one of the things she would do, so, just keep an eye on her. What is Rebecca doing during her actions? Yeah, she got out with me to make sure the kids were okay, yeah, but she didn't do it. Sure, talks to the driver. No, I don't. The driver, I don't. The driver. Is there anything less than that? No.
Okay. When that story was told, that Rebecca hopped out, and she went around and talked and checked to make sure the baby was okay, he invented that lie, which tells you that he is capable of lying to a police authority. Now, was it because he was worried about driving under the suspension issue? Who knows? That's immaterial. The fact of the matter is, in the face of a child who's suffering, and he's being questioned about this case, what does he do? He chooses to lie, and he is certainly capable of that. And what else is he capable of? Just so that you know. Who's in charge of punishment here in this family? You know from his reaction to a statement made in context, and you'll get that momentarily, with respect to who's in charge of punishment, you'll know that Brad is in charge of punishment. Brad? So what exactly is he responsible for with respect to punishment? What did he say about his method of punishment? When Rebecca doesn't punish enough, what was his response in the text message? What did he say? Smack her hand harder, or smack her cheek. She has to think she has to not think you're joking, babe. Okay? And then, with respect to her mouth, her impetigo, wow. 1, 2, 3 down in blue. Wow. I have smacked her mouth cut and all. So she really felt it. What kind of person takes a 2-year-old child who's got a really, really sore mouth that's obvious to everybody, and the way you're going to punish that child is to smack her in that cut? Now, this fella is a medic in the military, was a medic in the military, and his method of punishing a 2-year-old is to smack that child in a place where the child is already... What does that tell you about his method of discipline? This is not the timeout guy. This is the guy that you need to do more. You need to do it harder, and you need to inflict really severe pain, because that's what's going to happen to a little 2-year-old who's got a mouthful of impetigo, and you're smacking her in the mouth cut to make a point. Tells you about him. And by the way, with respect to what you've seen in that statement, I want you to remember that he knows he's on camera. I want you to know he's playing to the camera, so that when the tape rolled on and on and on and on, and then we finally get to that one point where he volunteers without anybody saying anything because he's a woman, reason. Oh, why is she lying? Why is she lying? He knows he's on tape, and he's playing to the camera. And is that just me saying that to you? Or, I don't think you missed it, but in case you did, I'm just going to play this little portion of the tape so that you know that he's on tape. He knows he's on tape. He knows he's on camera. He's sticking to his denial. And everything that he does in that tape is about him. And you have to ask yourself, how controlling of a fellow is this? When Rebecca came into that room and sat down, and she's falling apart as you observed, not from what she said, but just from what you observed, what does he do? Did he get up and come around the table and comfort her? Let's take a look. He is the one who has her come to him. Does he then proceed to say, what are you doing to me? I'm looking at 10 years for this. You're throwing me under the bus. It's all about him. Never once throughout his entire statement did he ever say, I recall, you're the one who played it back, tell me about her condition. Tell me how she is. I'd like to know. Is she going to be okay? People, No. It's all about him. And it's not all about him. At that time, it was all about Kinsley. Members of the jury, at the beginning of this case, Mr. Schiavone III, his opening statement, said the evidence will show Rebecca was in love and Brad was in lust. And you know, members of the jury, perhaps that's true, but regrettably, Brad did not make room for the love little Kinsley needed, and without it, everything was about him. And she died as a result of that. At the conclusion of this case, I expect you will review all of the evidence in detail and thoroughly go through this case. As simply as it is, nevertheless, I expect you to do that. And at the end of the day, I'm asking you to find this defendant guilty of causing the death recklessly of this little girl by abusive conduct, proved beyond a reasonable doubt. Thank you.
Thank you, Mr. Miller.
Thank you.
Ladies and gentlemen, the jury, I'm going to give you a little break before we start this closing. We'll recess for 10 minutes. During the course of the break, remember to abide by the admonitions that I shared. All right. Ladies and gentlemen, I ask that you stay in your place, remain silent, rise, and give the jury the opportunity to